Hello and welcome to the Kenneth A. Law of His Legal Podcast, the NJ Laws Tube. And in this edition, we look at the defense to possession of marijuana charges. Let's see, and this is based upon an article by the New Jersey Law Journal, which was published on this topic. Now, the defense of a person charged with possession of drugs requires a skillful approach. There are a number of viable defenses. In New Jersey, the Municipal Court has jurisdiction to hear marijuana cases that don't involve distribution, failure to deliver cocaine, and small amounts of drugs where the prosecutor just determines that they're going to be remanded to the Municipal Court. Now, at the initial interview, it's important that the person charged with the offense brings a copy of the complaint and writes down whatever they recall saying to the police, because that's important that possibly a motion be made to suppress any statements, a motion be made to file for a suppression motion. Now, if convicted, the court in New Jersey must impose a minimum $500 drug enforcement fee, fines of up to $1,000, jail of up to 6 months, probation up to 2 years, and there's a mandatory loss of license between 6 months and 2 years, unless there's a proven extreme hardship motion. Let's see. So the attorney should provide a written retainer agreement. Now, there are options to having trials. For example, the attorney can make a motion for what's called a conditional discharge, and that your attorney will explain to you. It's similar to being on probation for a year for someone who's not previously been charged with that type of offense. The granting of the conditional discharge is optional with the judge or the prosecutor, so the defense counsel should be able to prove, through letters and other documents, that the person would be a good candidate for the conditional discharge program. There's still different fees and costs involved, but if the person successfully completes the conditional discharge, then at the end of that period of time, the offense is dismissed. It's not erased, so someone would have to hire the attorney then to file a separate expungement petition. Let's say someone has priors, or they want to fight the case. A demand will be made by the attorney for what's called discovery. The prosecutor is responsible to provide full discovery. If discovery is not provided, then defense counsel can file a motion to dismiss for failure to provide discovery or compel discovery. Timely motions to suppress evidence should be made pursuant to the court rules. Also, for the state to prove that the item is marijuana or whatever drug, they have to have a lab report brought in, and under some instances have the lab technician come to court and testify. Now, there was a change in the New Jersey court statute some years ago that if there's no objection by defense counsel, the lab report goes into evidence. But defense counsel, more competent, will file a written objection to that lab report, and therefore there had to be a hearing with the witness, lab person, whether or not that lab report goes in. And that's also based upon State versus Ibarra and Crawford versus Washington. Let's say the motions are not granted, certain things aren't available, then there's trial. And prior to trial, person charged should have their defense attorney subpoena necessary witnesses, because sometimes under constructive possession there could be 3 people in the car. All are charged, person who's says it wasn't mine, it was someone else's, so they can be subpoenaed. In constructive possession, the state has to prove the person had the ability and intent to exercise dominion and control over those drugs. Let's see. If there's a trial, the state has the burden to prove that it was a proper search and that the drugs belonged to that person through the actual constructive possession. Let's see. So it's important. There's a lot of preparation work to succeed with a drug case, and let's see. It's important that someone charged with the offense not wait, but sit down and consult with a competent attorney early on. For other information on criminal defenses, contact the law office of Kenneth Vercammen. You can look at the website www.njlaws.com, or website benotguilty.com. That's benotguilty.com. Ken Vercammen's law office is at 2053 Woodbridge Avenue, Edison, New Jersey. Phone number 732-572-0500. Thank you and good luck.